Good afternoon and welcome to the Washington Voting Rights Act webinar. Today we have Linda Gallagher, legal consultant with MRSC, and John Safarli, partner at Floyd, Pfluger, and Ringer, who are here to share with us some background resources available to counties on the WVRA. All attendees are muted for this presentation. We do encourage questions, and you can type your questions by clicking the Q&A box at the lower part of your webinar window and typing your question in there. This webinar is being recorded and a link will be provided to you within 48 to 72 hours. This webinar will also be added to our YouTube page, which can be found by going to wasac.org. Thank you again for joining us. And now I'd like to welcome Linda Gallagher.
Hello, I'm Linda Gallagher. I am one of MRSC's legal consultants, and I am happy to be here to help us kick off our presentation today about the Washington Voting Rights Act. Let's see. First, here are some of the things that that John and I are planning to discuss today, and we look forward to also seeing your questions. First, evaluating and responding to a Washington Voting Rights Act notice, WVRA is our abbreviation. Next, how counties are handling these notices. Then we'll talk about the good faith collaboration or good faith effort that is required by this law. We'll talk about the remedies, and the remedies depend on an accurate analysis of population demographics and voting statistics. Next, Superior Court approval is required by this law. There was also a 2019 amendment that clarifies the timing of new district-based elections after a remedy, either voluntarily by a municipality or by order of the court or with a notice from a voter challenging the systems. There are two recent Washington Voting Rights Act notices, one from Ferry County, one from Yakima, and then we will also leave some time for questions and answers. First, I want to take just a few minutes to provide you an overview of what we do here at MRSC. In case you're not familiar with our services, MRSC stands for Municipal Research and Services Center. It has been in existence since 1934, that's 85 years. Our mission is to inform municipalities and provide guidance on legal, policy, and finance issues. We have 6 legal consultants like me. We have also a number of public policy and finance consultants, a communications team, an IT team that help keep our website current, and we provide research and guidance in a nonpartisan, independent, and accurate way. We do not lobby or take sides on policy issues or disputes. Sometimes one of us may have an opinion we would share with you, but we try to clarify. I'm putting my Linda hat on, not my MRSC hat. We also do not provide legal representation or serve as legal counsel. And that's an important distinction to think about because conversations with us or communications back and forth are not privileged or confidential as they would be with your own attorneys. For that reason, we use this legal disclaimer in our communications and on our website that we're a statewide resource and we provide general legal and policy guidance pursuant to an RCW. The communications are not confidential and privileged. In fact, this PowerPoint presentation is a public record under the Public Records Act, and I am imagining that the video itself also would not have privilege. So we're here today for a general discussion. It's the beginning of the discussion, or if you like baseball metaphors, the early innings of the game. But for a deep dive or specific advice about a particular legal issue, including what's happening in the counties that have received Voting Rights Act notices recently, that confidential part, we refer you to your prosecuting attorneys and also to attorneys that are experts in this type of work, such as John Safarli and his firm. With requests from counties at MRSC, we receive requests from all different municipalities, but requests from counties, we copy the prosecuting attorneys. We copy your prosecuting attorneys on the responses we provide, and we also let the inquirers know that. Sometimes the deputy prosecuting attorneys, or in a smaller county, the prosecutor will be the one to ask us the question, but often it might be one of your clients or one of their clients, or perhaps a department head or an administrative person or an elected official. But responses from counties, we provide copies. And we also refer to the prosecuting attorneys for the details on the legal issues. We have a number of research tools. There's not time today to share those with you, but you can find them at mrsc.org. We also have publications at the same website, and we have right now a rather robust and in changing each day series of topic pages about the coronavirus responses. So you can find that at our website. But let's turn to our topic of the day, Washington Voting Rights Act. This is a new law that was passed in 2018. It's in chapter 29A.92 of the RCWs. It's based on California's state act, and both Washington and Californians go further than the federal Voting Rights Act. Our law applies to all counties and most other municipalities, including cities, towns, school districts with populations over 1,000, and also many, I meant to say other, not outer, special purpose districts. On the next slide, I have summarized parts of the act, and today we're not going to go over the entire everything in the act, but just the details that are relevant to trigger further discussion or further inquiries. Municipalities are authorized to voluntarily change their voting systems. Prior to this law, there were other RCWs where even if you wanted to go to a district-based general election instead of at large, an RCW may have prevented that. The Washington Voting Rights Act makes clear that municipalities can voluntarily adopt these changes. Voters in the municipality may file a notice to seek a change in your voting systems at the county or another agency. A remedy happens either with negotiations with the municipality by agreement, or if there's not an agreement, a court order. So, and then Superior Court approval is required even if there is a remedy by agreement. One of the provisions in the Act, it's in 0601, is about how voter challenges to electoral systems are presented. There are notice requirements. So a voter who resides in the political subdivision, so your county, a voter who is a voter in your county and intends to challenge your electoral system is required to first file a notice with the county. And then there's a requirement that the county or political subdivision promptly make the notice public. The notice has some requirements. Early versions of this bill that did not pass had more requirements, including providing all the data used and more specifics, but those are not in the law. The notice does require that the notice identify and provide contact information for the person or persons who intend to file the action. I highlighted this. It's interesting because it doesn't directly say the voter in your county must be identified with contact information, although it seems like the logical meaning of what it means. But it says the person or persons who intend to file an action. And that'll become maybe relevant when we talk about the Ferry and Yakima County letters of notice they have received. The notice also must identify the protected class or classes whose members do not have an equal opportunity to elect candidates of their choice. And that's not always by agreement with everyone. That's an argument that's made. But there's voter inequality is the purpose of the notice. And then the notice is also required to include a type of remedy that the person believes may address the alleged violation. Mostly this is district-based voting rather than at-large voting, the general election. It could also mean though redistricting the districts in order to have the protected class or classes have a better chance or more influence, I guess, in the outcome of an election. Now, this is important. The key or the heart of the Voting Rights Act is the good faith collaboration. And that's the political subdivision entering into a process of good faith to find a remedy when you receive a notice like this, or even when you're doing a voluntary change to your election system. The county, in this case, the political subdivision, so any of these municipalities, but here for the counties, shall work in good faith with the person providing the notice to implement a remedy that provides a protected class equal opportunity to elect candidates of their choice. And this work in good faith may include, it's got three things, but it's really everything, but it's two plus any other information: electoral data, demographic data, and any other information. And this process is the person that is lead for the county reaches out to the person providing the notice with legal advice and information, armed with the information needed, the demographic and electoral data, to work together to figure out a remedy if there's a basis for agreement rather than litigation under the statute. Original versions of the bill, it's not in there, but had a meet weekly or meet monthly with the person providing the notice. And then those provisions I don't think are very workable. They don't fit the particular individual circumstances that each notice may have, but they're not in this law, but it might be some kind of guidance for once government is back to normal now after the current crisis, having regular meetings or having opportunities and ways to demonstrate your good faith and do the research and figure out whether a change needs to be made and what change to adopt. Now, court approval is also required. And so even when the subdivision, the county adopts a remedy by agreement or not, there's a requirement to seek a court order acknowledging that the remedy complies with the RCW, the Washington Voting Rights Act, and that it was prompted by a plausible violation. This is interesting language to me. I'm not sure. A plausible violation I don't think is defined in this act or otherwise, but to me it leaves room or open for a agreement to disagree about whether or not there is a violation, even if you're seeking a court order to approve a remedy that's happened because of the good faith collaboration. The other interesting thing in this provision to me, I've highlighted at the bottom, there shall be a rebuttable presumption that the court will decline to approve the political subdivision's proposed remedy at this stage. And that's when you first go to Superior Court and say, here's our remedy, we are asking to approve it. That doesn't make a distinction between when it's an agreed remedy as well. It's basically a shifting, I think, in my mind. John may have something to say about this as well in his part, but it's a shifting of the burden of proof to the county or the agency, public agency, rather than the plaintiff when you're seeking the court approval. The person who submitted, the voter who submitted the notice to the county can either agree or oppose the court order that's being sought. There's reference to public records. There's also a requirement for the county or other agency to provide all of the data, political, census, and demographic data, and any analysis of the data used to develop the remedy. So there's a requirement to go to court, and the court needs to look at it. And this last sentence directs at least to an extent, purports to direct the court to how it should make the decision. And that's an unusual provision to see in any RCW. Well, maybe not any of them, but it's unusual. Originally, there was a provision also with direct appeal rights to the state Supreme Court. That was taken out, and that was also an interesting thing to talk about while it was at the legislature, but you don't have to worry about that. There's a right to an appeal, and as there would be in any court ruling, but with the Washington Voting Rights Act, they want to make sure there is a court order that approves the remedy adopted. There's also a provision where the agency may stipulate to the person's proposed remedy. That can be by stipulation. It's maybe a toss-up whether it means the one they proposed from the beginning or the one that is proposed as a result of the good faith collaboration and efforts to implement a remedy. Switching to from at-large elections for your general election to district-based elections is probably going to be the most common one that people propose, but there may be others as well. Timing for adoption of a remedy. This is interesting. There is, until July 1 of next year, 2021, a municipality has 180 days from receipt of a voter challenge notice to adoption of a remedy and getting the court order that approves the remedy. This time period goes from 180 days or 6 months down to 3 months for notices that come a year from this July. Now, an interesting question here would be how the current emergency declarations from the courts might affect the two notices that I've seen, the Ferry County and the Yakima County one, because it seems that days when the courts are closed or when the county government is not able to function as normal to continue with this process, those days maybe shouldn't be included in the 180 days. But that's probably best resolved by a negotiation or other suggestions from the people actually working on those notices and their attorneys. The timing of the next elections after a remedy, there is, let's see, it's based on when the court order, the date of the court order approving the remedy, triggered by the date of court approval. If there's an appeal of a court order, then I think you would likely look at the date of the mandate back down from the appellate court when the appeal is over, because that's when the Superior Court order would go into effect. If the court approval or court ordered remedy is entered basically between election day and November of one year, so it says, and then January 15th of the next year, then the new elections would happen at the general election of the year that the January is in, whether or not it is an odd or an even year. Here's the RCW itself to look at, the timing of the next elections after a remedy. This is in RCW 29A.92.1103. A little bit interesting. It says that if the time period is between the first Tuesday after the first Monday of November, so that's when we have elections in November, and on or before January 15th of the following year. So if the court order approving a remedy to change how you do your electoral system happens during that time period, then the court will order new elections, or under the other RCW, new elections will be held at the next succeeding general election. The next provision says if it's between January 16th and on or before the first Monday of November, the next election will occur as scheduled and organized under the current way. So right away, you wouldn't have to change up to the new system, but then the court would order new elections the following calendar year. Interesting what happens, I don't know, but between the first Monday of November and the first Tuesday after the first Monday of November, there's a gap there of about 8 days that don't seem to be covered here. But so I'm guessing in that second provision, they meant to also say between the first Tuesday after the first Monday, or on or before the first Tuesday after the first Monday. Then the last provision here, all positions on the governing body must stand for election at the next election for the governing body. So it means you don't just take the whichever districts are staggered. Everyone gets reelected at the same time. After that, the governing body may subsequently choose to stagger the terms. There was an amendment last year in 2019. That amendment clarified that when there are new elections, either voluntarily or by court order under the Washington Voting Rights Act, then the elections are for all positions in the next general election. I originally thought before this amendment, I thought it meant the next general municipal elections. So if it's, it would be on the odd years, but then it's a long time to wait till the next election. So in 2019, they passed an amendment to clarify that this is the case even when the next general election is a national election held in even years, rather than a municipal general election held in odd years. There are two notices. I'm just have a couple brief comments about them. I think John's going to address these more. Ferry County has a notice letter that's brief. It's less than 2 pages from January 9th. It did not include the name and contact information of a voter in the county. Now, is this required by the RCW? The RCW says identify the person that will be filing the action or that's pursuing it. So that I think theoretically that could be an organization instead of the voter, although the RCW appears to mean the voter. That letter is on behalf of the Colville tribal members residing in Ferry County, but no one is identified as the voter that is challenging the system. That notice proposes a remedy of in-district voting and invites a voluntary remedy to avoid a court action. In Yakima County, a notice much longer with more detail, 6-page notice letter came. January 15th is the date on the letter that I saw, and that was presented on behalf of 4 named voters and an organization called One America. That letter challenges at-large voting as violating the rights of the voters and proposes, though, a ranked choice voting system rather than just changing from at-large voting. Let's see, there are 2 blog articles on our MRSC page about these new laws that I wrote, and you're welcome to go look at them later on. I don't have details or time to discuss the details. Essentially, though, this law, it's a big change potentially. It recognized the importance of the right to vote. It's fundamental and a valued civil right, and is striving to take measures to improve our voting systems so everyone is represented in the electoral systems. Now, we remain in the early innings of the Washington Voting Rights Act. It's a new law. Case law is likely to be developed over time. There will be litigation of disputes, I believe, about whether and to what extent remedies are needed, and this will develop over time as well. We are watching and learning from the first experiences and test cases for voluntary adoption of remedies and handling of notices of voter challenges to potential violations of the Washington Voting Rights Act. For example, though, what if a county is changing its system, not because of a voting rights violation, but simply to change the system or improve it? Would that be required to be under 29A.92 of the RCW? Or could you change the system under other authority? The city of Wenatchee, I believe last year, changed to district-based voting, but expressly did not do it under the Washington Voting Rights Act. I'm not familiar, though, with any experiences yet in counties for this. So in the early innings, that leads to the one picture I have in our slideshow here, where the baseball game, you never know how it's going to end up. So we'll see how the next innings go. This is an example of social distancing if you're the players on the field, but the crowds will need to wait until life gets back to normal. And with that, I would turn over the presentation to John Safarli. Thank you.
Okay, thank you, Linda. This is John Safarli, and I'm going to be sharing my screen here now. First of all, I want to thank everybody for attending live. I know lots of people will watch this as a recording, but thanks for being here today, during these, I think it's fair to say, pretty challenging times. So thank you, Linda, for an excellent presentation and leading into my half of it. I want to echo a couple things Linda said. First, I am an attorney in private practice, and I do have clients who I represent, but I am here just as a presenter, giving my own opinions on the law. And, if I comment on the law itself, that's purely just an expression of my own opinion, not on behalf of any of my clients. And also, as Linda said, this presentation is not intended to be legal advice about specific situations, but you're certainly welcome to contact me or other attorneys or resources like Linda to get further guidance. So with that, I will go to my first slide, which is, oh, my apologies, hold on. Okay, so first question for the audience, both live and recorded. Where do you find your county? What position is your county in? And I have three positions that I think counties can find themselves in. The first is that you have not received a notice letter and you don't know if one is coming. Number two, you have not received a letter, but you have a pretty good feeling one is coming. And then third, you have received a letter. I think each one of those situations calls for different types of tasks. So let's say you have not received a letter and you frankly don't know if one is coming. It's still worth, if you're considering this issue, to look at the recent community mood. Some of the examples I give, has anybody made public comment during meetings? Has there been any social media activity? Up in Everett, there was a group that was formed called Everett Districts Now, and they were very, organized and promoted district-based elections. And so that was an example of social media where you can kind of see that maybe something's on the horizon. But if you don't see anything one way or the other, at least you've sort of taken the temperature. But there still may be changing demographic trends that would be worth considering. So as Linda alluded to, sometimes jurisdictions are interested in changing their election system, not because there's any threat on the horizon, but just because it would be beneficial to the residents there. So if you have a demographic trend, maybe you want to take that into consideration. So if you say, well, based on just what's in front of us, meaning, the public comment, changing demographic trends, if the county feels like this is something they want to pursue, regardless of whether there's a letter on the horizon, you can hold an executive session on this issue. It's a little bit trickier in the sense that if there's no letter that's been received, or if you're unsure if the letter's coming, whether you can invoke this executive session rule for anticipated litigation is, I think, fair in this situation, because even if a letter has not been received, or you don't know if one's coming, there's still a reasonable possibility that, quite frankly, anybody could be challenged. Any election system could be challenged under this law. We can talk about that later, but this law is fairly broad in its scope of who it can target. So I think, given that, executive session is a fair right to invoke. Create a record of exploration. Have presentations done and presented at public meetings. Here we looked into this issue just because we felt it was the right thing to do. And here's sort of a record of what we put together. That can be memos, that can be letters, it can be a summary. But if you want to go down that voluntary process, and by the way, you can create a record of exploration without actually going into the voluntary process itself. But if you do go down that process, there is a specific procedure that's laid out, and I can get into that a little bit later. But then there also is this wrinkle that might be of interest to people who have studied this law very carefully, and that is the Washington VRA gives local governments the authority to voluntarily change their election system, regardless of whether there's a threat of litigation. But the language in the Washington VRA says that that can be done for a potential violation. So in other words, if you're a county that says, we haven't gotten a notice, we don't think we're going to get a notice, let's go ahead and change our election system anyway. If you fall in that category, the law still hints that there needs to be a potential violation that you suspect could be out there. So it's a little wrinkle. I don't know who would actually enforce that provision. So it's out there. But if you have further questions about, exploring the possibility of voluntarily changing your election system, do we need to build a record of a quote unquote potential violation? I think the short answer is probably not. But if you want to do that anyway, just to, completely mitigate risk, that's something that can be pursued. All right. If you have not received a letter, but and actually that heading should be if you believe one's coming, or even if you're unsure that one's coming and you do get one, the next move to make would be to speed up the process of the voluntary change and retain outside counsel and coordinate with experts. And the reason to do that is to have a hit the ground running package ready. Develop knowledge about demographics, previous elections, potential options, etc. So this is important when you have not received a letter, but you're unsure if one's coming, or you now believe or know that one is coming. The reason that this is important to speed up the process and retain counsel and experts is because if you know a letter's coming, you have 180 days to get a court order approving a remedy, potentially. So that's 6 months. And I think we all know, as county officials and employees, you all know this, that 6 months is not necessarily that much time. And I know that firsthand from working with local government. So if you haven't gotten the letter yet, and this is still where we're at, if you have not gotten the letter yet, but you think maybe one's coming, that time is very valuable because you can develop knowledge about demographics, about previous elections, and you can get the advice of legal counsel. You can do all that before you get the letter, because once you get the letter, again, you have 180 days. So you can use this time before the letter actually makes its way to your doorstep to be able to come to the table ready and use those early days to negotiate as opposed to figure out what is what do we do? We've got a notice. Okay, we need to start onboarding people. Well, you can start doing that onboarding process beforehand to again hit the ground running. So we're in the third category now. So the first two were have not received a letter, but you're unsure if you're getting one, and then you have not received a letter and you are pretty sure that one is coming. Those were the two sort of categories we've explored so far. Now we're into the territory of you have received a letter. Important thing to know is that no lawsuit, as Linda indicated, can be filed until 180 days after the county receives notice. So you're working with 6 months. That changes to 90 days. Linda raised a good point about how does the health emergency out there impact potential discussions. Well, I'm in the middle of a good faith discussion with another party in a matter, and at the end of their most recent letter, they said, we understand COVID-19 is wreaking havoc on resources, so if we need to take more time on this issue, then we can. So I thought there was a very admirable thing to put in the letter. We'll see where that goes, but it definitely has started popping up on current matters. The county, according to the law, has to make the notice public. It has to post it online, presumably. As Linda alluded to, the notice can be tricky sometimes. First of all, the law does not say who it needs to be served on at the county. So you could potentially have a front desk person getting the notice, but hopefully the legislature will address this. But if anybody gets the notice at the county, you just assume that it's been served on the county itself. As Linda indicated, there's not a lot of information that it has to contain. It has to contain, sort of identification of who's disadvantaged by the status quo, and then also a proposed remedy. But it's a little light on information, and I think that brings to this last point of the residency of the voter. I mean, presumably there has to be some kind of proof of residence, but I don't really see courts, and this is just my own personal opinion, I don't really see courts enforcing the notice part of this law very strongly. I think there's going to be a lot of lenience given by courts. So I'll just leave it at that. I just don't expect to get a case tossed based on notice under this law. Interestingly, the lawsuit does not need to be filed by the same person who served the notice. So potentially you could have a different voter bring a lawsuit than brought the notice. Okay, so as Linda alluded to, after the letter has been received, the county shall work in good faith with the person giving notice. That is an information sharing process that both sides have to go through. So one thing that's important to know is the county can demand information from the voter who sent the notice too. Say, well, what are you relying on to assert this claim? You can ask for that information from them, but they will ask it of you. And what information it gets requested, that goes into a lot of detail, but I can certainly answer that later. This is important, okay? We talked about the 6-month window that you have. Well, what's important to know is that if the county wants to avoid a lawsuit, then it could adopt the proposal from the voter. Even if it does goes that route, you still have to obtain a court order within 180 days. And I think that's really important because, working with courts, as everybody in the audience, live and recorded, knows, the courts move slowly. So you could potentially be looking at, a 3-month process in the court, especially because the judge is going to be very nervous about rushing to a decision. So I think the court would probably say, hey, if anybody wants to intervene, you've got 30 days to do so. So that's 30 days on top of however long it takes the court to decide which proposal to accept or whether or not to accept a proposal in the first place. So, and also judges are going to have to be learning from the ground up on this area of the law. State court judges will. So it's going to be a lengthy process to get a court order. So really, you don't have 6 months to negotiate. You have 6 months to negotiate and then get a court order if that's what happens. And then, as this indicates, a lawsuit can be filed on the 181st day. So I think it's kind of be a bizarre scenario, but I could see a situation where the proposal is in the pipeline in the court system and the 180-day mark passes, and then there's a lawsuit filed. And then it gets into this mess of, well, we have a pending proposal before the court. But just to avoid that kind of logjam, I would be mindful of the fact that you have to obtain a court order within 6 months. So after you get the letter, here's what you can do. You can do nothing, maintain the status quo and defend it in court. You can agree to replace the status quo, but have disagreement about the remedy. And then you can agree to replace the status quo and agree about the remedy. So let's say you've received a letter and you say, I don't want to do anything about this. I don't think anything's wrong with the status quo. Well, I would suggest having outside legal counsel or in-house legal counsel who are familiar with this issue to evaluate the strength of the lawsuit. And that's a little bit tricky in this area because here are the two elements of the claim: that the elections exhibit polarized voting, and then members of a protected class do not have an equal opportunity to elect candidates of their choice. Those are heavily, heavily defined terms in the federal case law. And so it's tricky to evaluate a claim in terms of the strengths and weaknesses because it requires a pretty deep knowledge of how the federal courts have decided these cases since the 1960s. And the other problem is you don't really know how much of that federal case law states are likely to adopt. So it's, evaluating the strengths of voting rights lawsuits can be done. It's just there's a lot of unknowns. But that information that you can obtain is important to decide whether you want to go to court and defend the status quo or take a different route. If there is a lawsuit filed, it has to be filed in the Superior Court of the county of either of the nearest judicial districts, and attorney fees are recoverable. So these are just kind of the, topics to consider if you're thinking about defending the status quo. But again, as Linda said, I don't want to give any advice here or during the Q&A on a particular county. If that is an issue, if that is a question, I can certainly take that up outside the context of this presentation. But there is also a option of agreeing to replace the status quo, but disagreement is about the remedy. So in other words, and I've been through this process where the local government says, look, we agree that this was, by the way, done under the Federal Voting Rights Act, but there is a sort of an agreement that, look, you could prove your case in court. However, so we don't want to fight on liability. However, we don't agree with the remedy that you're proposing. Well, then you end up with kind of a mini lawsuit where if you're the county, you would submit your proposal. You'd say, look, Your Honor, we know that the current status quo violates the law, but we would like to replace it with this remedy. Interesting side note, the Washington VRA, is silent on which county the proposal gets submitted to. Presumably, it's the Superior Court of the county that is subject to this claim, but I don't know. I mean, it doesn't say. Whereas, as I mentioned earlier, the venue issue for lawsuits, it says the county of, or the Superior Court in the county of, or the neighboring two judicial districts. This provision doesn't say which Superior Court. So anyway, that still is a step that the county has to take. And as Linda mentioned, the Superior Court has to do two things. It has to construe facts and inferences in favor of anyone opposing the proposal, which means in baseball, the tie goes to the runner. Well, what this means is that the tie goes to the party challenging the county's proposal. Then there is this rebuttable presumption that Linda mentioned. I do not, as my personal opinion, I do not understand why this is in the bill or law because it just is very extreme. I'll put it that way. I can explain more outside the context of this presentation, but it's a very extreme measure to have in the bill. If the Superior Court agrees with the county's proposal, then you have a safe harbor for 4 years and no attorney fees to the plaintiff. So it's again, prevailing in front of the judge after you've admitted to a violation can get you out pretty cleanly, assuming the judge agrees with your plan. But if a judge does not agree with your plan, then the court will fashion its own remedy. And that could probably be the remedy proposed by the other side or through a court-appointed expert. What if you agree to replace the status quo and you agree about the remedy, that'd be great. Again, no friction, no conflict. Well, it's unclear if then a third party or a non-party, as I call it here, could intervene. The law seems to say that no, the only people who can really challenge the proposal are the people who submitted the notice. And if the person who submitted the notice stipulates to the proposal and the county and the person go arm in arm to the courthouse, can anybody prevent that? My guess would be yes. So even though I'm quoting the law in italics here, I think a judge is likely to read that pretty expansively and say, well, the law only explicitly references the person who submitted the notice, but I will allow non-parties to intervene and block this remedy. And if that happens, then you have the same challenges. So the construing facts and inferences against the proposal and the rebuttable presumption against the proposal. Those are both applicable, even if it is a joint stipulated proposal, assuming the courts allow non-parties to challenge them. Okay, so this is really important because when I've been discussing this issue with clients, this comes as a complete surprise to them, and it's very discouraging for the clients because it's a very unfair part of the law. Again, my own personal opinion, but here's what happens. So the date, as Linda said, the date is very important. So the date, if there's a voluntary change, when was the new plan adopted? And then if it was a court process, when was the court order issued? Okay, so those are the two questions you have to ask yourself as far as timing. The first scenario is if the voluntary change or court process was completed between the middle of November and the middle of January, then all commissioners must run for office under the new system in November of the following year. So again, this is important to stress. Even if you have voluntarily changed your election system without the threat of a notice letter or having received a notice letter, even if you voluntarily change your election system, you still have to have these new elections held. The other problem is that if you have, let's say, gone to the court together and said, we have this new proposal, we actually both agree on it, there still has to be brand new elections. And that's inevitable. So even if it's under scenario number 2, which is if the plan is adopted between mid-January and mid-November, so that's a big chunk of the year, you still have to run fresh elections for everybody, but you're one year out from that. So if you're adopted during most times during the year, you have to then conduct elections as you would normally, including the seats that would normally be up for office. And then following year, everybody runs for office. So even the people who ran that immediately prior year, they have to run again. I'll just be candid. I think this is kind of a poison pill because if you are wanting to encourage participation in the election process with local governments, great, but you have essentially punished these commissioners by forcing them to run for office again under the new system. So I just think it makes it more difficult to sell your case. If you're a voter, or if you're a voter group, you represent voters, I just think it's harder to have an agreed upon path if the commissioners know at the end of that path is re-election. I'm not speaking for commissioners. I'm not even, that's just my own opinion on this, because I do think it's a real challenge, because elections are expensive, they're tough. Now, of course, there are commissioners and other elected officials who have taken the approach of, if that's what has to happen, that's what has to happen. So I want to give credit to that position as well. But at the same time, having this as a automatic process that happens no matter what route you take in terms of being proactive and so forth, this gets triggered. I just think it makes it harder. Or makes it harder in more cases than not. So that's important, but I want to just run through some brief topics here, and I won't go into detail on all of them. But you should know that there is a safe harbor out there. That's important. However, the safe harbor doesn't apply if there's a voluntary change process. And just to be clear, when I say voluntary change, I mean any process where there hasn't been a notice letter yet. Voluntary change means pre-notice letter. So if you have not gotten a notice letter and you change, then you don't have a safe harbor. But you do have a safe harbor if you've gotten a notice letter and you went to court and you got court approval. And then there's some other specifics about the safe harbor. The voluntary change process, again, pre-notice letter, has its own requirements, and I spell some of those out here. And then also, this is maybe a subject if anybody's interested during Q&A. How does the census impact things? That is certainly an issue. I'd be happy to address it in Q&A if anybody's interested, but I know my time's up. So I will turn it back over to our leader for questions.
All right, well, it looks like we don't have any questions quite yet, but we will give it a minute for any attendees who have any questions. Again, you can click on the Q&A tab at the very bottom panel of your Zoom meeting and open up the Q&A panel there and write a question. We'll give you a minute to ask that. If there are none, then we will close the webinar, but we'll give it a minute for anyone looking to ask some questions.
And while you're writing the questions, this is Linda again. Just wanted to thank you, John. That's a lot of the details you had there were things that I was thinking, oh, I wish I said that too. And I agree. And it's just, it's an very important, but also a complex issue to work through this law. There may be some changes that would be useful both to voters and the protected class voters, and also to counties and other agencies. And I'd encourage those of you who are leaders in that field to look at that, and again, refer you both to attorneys who are experts in this field, and also to your prosecuting attorneys and your deputies that are whoever is most interested and most expert about your election systems.
Thank you for that, Linda. It looks like we don't have any questions from the attendees. So, we just got one in. A couple of them in. Perfect timing.
There we go. Give people time to write. Yeah.
Yeah. First question: what if a protected class has their own government government outside of the county?
John, what do you think?
Well, I'm not sure I understand the question totally. I think if I could get a clarification from Mr. Davis on what that question means, that would help.
Okay, well, while we wait for that, let's bump to the next question. It is my understanding that there is a consistent voting method set throughout the state. If that is the case, would the Washington State Constitution have to be amended in order to proceed?
That one I can at least start. I don't think the state constitution needs to be amended because each county has the statutory authority, and I think probably constitutional authority as well, to establish the way you elect your commissioners in your counties. There are some with charters and then most without, and there is, and under the Washington Voting Rights Act, there is the option to have your own voting systems. What do you think, John, though? I mean, the Constitution obviously comes first, but.
Right. No, actually, this is a great question. I've gotten it a few times, and
Good.
I think I can answer it in a way that's not providing specific legal advice, because this is really an issue about what the Constitution says across the entire state, as opposed to what the Constitution says regarding a particular county. So I think with that in mind, I think what the questioner is getting at is Article 11, Section 4 of the Constitution, which says that the legislature shall establish a system of county government which shall be uniform throughout the state, except as hereinafter provided. And so I know, I'm very familiar with that provision, and there is actually an answer to this in the law itself. The drafters of the legislation were cognizant of this, and they actually, at the beginning, if you go to the very beginning of the WVRA, it's RCW 29A92005. They actually put language into that particular statute that says, it refers to a case. It refers to a case called Mount Spokane Skiing Corporation versus Spokane County. And that case basically answered the question that we're asking ourselves right now. According to the Washington Supreme Court, that Article 9, and I may have misspoke earlier when I said
Nine instead of 11.
9. Sorry, I just said, yeah, I was about to say 9, but I said 11 earlier. Thank you. Article 11, Section 4 doesn't require actually that every single county operate the same way. It just says that the counties must have the same authority to operate in the same way. Whether they actually operate the same way, and that Mount Spokane Skiing Corp had to do with taxes and local issues. So the Supreme Court said that counties can kind of assess taxes or whatever, arrange things in a certain way, as long as they have the same authority. So back to the WVRA, the drafters said, they cited that case. They said, look, the Supreme Court has said that non-charter counties need not adhere to a single uniform county system of government, but that each county have the same authority in order to be deemed uniform. So I know that's kind of a long-winded answer to that question, but it's an important one because the Constitution is kind of looming large over this issue. But the long and short of it is, no, the WVRA is probably compatible with the state constitution, and the drafters of the WVRA knew that, and they called out that Supreme Court case that had to do with Article 11, Section 4. So anyway, I hope that answers the question.
And I agree with John. And let me go back to the question about if a protected class has its own government or governance outside of the county. In thinking about that one, I'm assuming you're referring to the tribal nations, perhaps. So if Washington registered voters also are part of the Confederated Tribes of the Colville Nation, for example, I don't think that would be any kind of defense to also having the protected class that has the right to vote under our state system and the county system. I think it still applies, or it does.
Yeah, I agree with that.
And it seems like you answered this question already as John went into a little bit more detail of the question prior. How does the Constitution requirement for a uniform system of elections conflict with the WVRA? Seems like this law could result in lots of different methods of elections. It seems like you answered that, though. Or is there
Yeah.
anything to expand on that?
No, just that yeah, I think that's the same as the earlier question.
Perfect.
And then is a new election required if just redistricting? I think that's a different RCW that applies to the redistricting. And I think your same electoral system would continue to apply unless you make a change under the Washington Voting Rights Act or otherwise. What do you think of that one, John?
Yeah, no, that's a great question. And there is, I think, an argument to be made, not by counties or their attorneys, but I think that what we might start to see is voters and voter advocacy groups start to argue that any change to an election system would need to comply with the procedural requirements of the voluntary change process. So if I could actually just share my screen again really quickly.
Yes.
The other topics.
Do I need to turn mine off? Let's see.
I think it went ahead and.
Oh, there we go.
So this here at the bottom of voluntary change process, written notice and radio/television PSAs in English and other languages, and at least one public meeting 1 week before adoption. I think what you're going to start seeing is you're going to start seeing these groups argue that you need to follow those procedural requirements and that you also need to stand for new elections, because they're going to say anything you do related to your elections falls within the WVRA, whether you think so or not. And I don't know how courts would come out on that issue, but I think that's going to be the argument that they're going to make. So I stopped sharing my screen, but
Here, I'll put mine back up. And then the question of what's the case name again that John cited, I'm reading it from the RCW, and the case is called Mount Spokane Skiing Corporation. So this is about your ski resort over there. Mount Spokane Skiing Corporation versus Spokane County. The citation is 86 Washington App 165. It's a 1997 Court of Appeals case. Found that non-charter counties need not adhere to a single uniform county system of government, but that each county have the same, quote, authority available, end quote, in order to be deemed uniform. And that's also in RCW 29A.92.005. So I hope that's helpful.
Yeah, and I just want to correct myself earlier. I believe when I was referring to that Mount Spokane Skiing Corp case, I believe I was referring to it as a Supreme Court case. That was, if I did, I apologize. It is a Court of Appeals case. But as far as I know, the Supreme Court did not accept review and had basically the decision has stood for almost, let's see, 20 years, 25 years. So it's a case that is not from the Supreme Court, but it is sort of considered the lead authoritative case on this subject, to the point where the drafters of the WVRA felt comfortable citing it in their RCW, which is 29A92005. So just want to.
Exactly. And it's part of their legislative intent for how to explain why their law is consistent with Washington law. They also referenced the Constitution earlier in that provision. If you want to.
That's true. Yeah. So I think we're at 3 o'clock or a little past it.
Yes. Thank you all for joining us or listening to it in the future. And we're available for questions. And John, if you have any wrap up, go ahead.
No, just thank you all for taking an interest in this issue, and good luck and stay safe out there. And yeah, thanks again for your time.
Thank you too for presenting on the webinar today. Again, this recording will go out in about 48 hours, and we'll also be including the presentation materials in that with Linda and John's contact information in there in case you need any further clarifications or anything like that. Thank you again for joining us. Have a great day.